Hi everyone, it's Rob Ryder. Today, one district court that trumps all. In other words, why the United States District Court for the District of Columbia is the general government of the United States. And it's not because Rob Ryder said so. I think that's what we're going to see in a Supreme Court case that I'm going to read. And that's mainly what this video is for, is for me to read this Supreme Court case and another document that kind of fits in about the history of the courts of the District of Columbia. But, that's one piece. And then how that fits into the idea that Article 3 district courts versus the U.S. U.S. district court, which you'll find they use both versions on different papers. And so the Article 3 district court, well, that's an inferior court of the United States. And the U.S. district court, that's a territorial military tribunal. And, it's an Article 1 court. Well, the district court, now they're called the United States District Court. Spelt out United States District Court, not U.S. District Court. And United States District Courts are the inferior courts spoken of in Article 3, Section 1, where the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. And that right there means United States District Court, spelt out, not U.S. District Court. And why that's important is because the judicial power of the United States, right, shall extend to all cases in law and equity arising under this Constitution, laws of the United States, and treaties made, or which may be made under their authority. Which means in a U.S. District Court, you should not be being tried for anything that has to do with the United States. Right? The United States shouldn't be a party. There shouldn't be a controversy between citizens of different states. That's an Article 3 power. Anything to do with law, equity, arising under the Constitution or the laws of the United States or treaties are in a Article 3 court, not an Article 1 court. And so, like for a criminal code statute 18 U.S.C. 1001, for instance, a false statement, that wouldn't be heard in a U.S. district court. It needs to be in a United States district court. There's a difference. One is Article 3 and has all the powers under Article 3, and the other one isn't and doesn't have any judicial power under the United States. But it is a territorial court. And so the Congress can write it, what it has jurisdiction over. It just doesn't have jurisdiction over things under the Constitution. More like a local government. And so if you would think back to, that was really like this, where Michigan is. It started out as a federal territory. And some general and some other officers came in, and the general became the governor. And the other officers became judges, and they sat in the four sections of Michigan as they described it, but they would get together to form a legislature, and when they were apart, they were judges of the district courts. They got together, they made the Supreme Court, so forth and so on. So that's a territory. But that territory isn't part of the United States then, because it isn't the United States. It's a territory of the United States. And so the court doesn't have any authority to adjudicate the laws of the United States. I guess that's the important thing out of that. So, hey, guess what? Today's Good Friday, 2018. In the name of the Father, and the Son, and the Holy Spirit. Amen. My name is Rob Ryder. That's my avatar. Email address is courtofrecord@aol.com. Phone number 616-712-6179. If you can, and you could donate, I could certainly use it. My PayPal account is robryder@aol.com, ROBBRYDER@aol.com. Or the snail mail, Robert Allen Ratlewski, RYTLEWSKI. That is my full legal name. 10955, 14 Mile Road Northeast, Rockford, Michigan, 49341. Or PayPal. This way, you could send it to Walmart, Western Union. Send me an email to Court of Record. Say, hey, brother, I got something for you down at the store. After all, we're working for the common good, and I work really cheap, but I do have to eat. So let's see what this could all lead to. What's going on today? So other than showing you a bunch of images, just to give you an idea of the different things that they do with the paper, and then I'm going to spend most of the time, like I said, reading a Supreme Court case and looking at what a history of the D.C. courts had to say. There's going to be a lot of me reading things that you'll be able to find yourself online. But I like to highlight it and point things out. So let's see where we're going to start. Where are we going to start? Okay. Here's an example. I did a video some months ago about Samuel G. Grodd. It was called Samuel G. Tried in a venue beyond the sea. Because Samuel G. was apparently in a court case that, where did I see it on here? Right, USA versus Samuel A. G. Grodd. Well, that's not the United States. Right? The United States isn't a party to this, although Samuel G. Grodd was supposed to have violated the United States laws. The United States isn't the plaintiff. The paperwork probably says United States of America, like on the indictment and so forth. Again, that isn't the United States of, it's not the United States. The United States of America is a kingdom of King George III's successors. And you'll find that in the Treaty of Peace from 1783 in the very first paragraph, where King George is talking, and he'll tell you he's the king of the kingdom, United States of America. And what else was there on this thing I wanted to show you? I'll get back to that one. Oh, here's the docket for that case. Right? USA versus G Grodd. It says U.S. District Court. Right? It's not the United States District Court, so this court doesn't have any power, authority, to adjudicate a case involving the laws of the United States. And anybody who's in a U.S. District Court needs to tell them you don't have any authority to adjudicate the laws of the United States. But when you look at how here's their pending counts. Now, normally you would think 18 U.S.C. 732, 18 U.S.C. 1505. You would if you've been doing this kind of stuff, right? That those would be United States Code violations. But they're not written. This isn't the proper citation for United States Code, right? It should be 18 U.S.C. 372. It probably should have that subsection double S thing in there they put, but this doesn't. So it's not that they're trying him for laws of the United States. They're trying him for things that are acting like laws of the United States in a court that doesn't have any jurisdiction or authority to adjudicate anything to do with the United States. Right? It's not the United States Attorney's Office, it's the U.S. Attorney's Office. So it's people wearing two hats. And, this U.S. court is something that I believe that President Lincoln brought into effect in 1863 as part of getting ready to do martial law. And that's all part of what we'll be reading. So, right, so I mainly wanted to show this. So here's a criminal case where Samuel G. and Samuel is he's a Amish, who was making some kind of salve out of buckwheat, and they ended up going to jail for, I think they're trying to charge him for 65 years. It was earlier this year. I don't know exactly where it is now, but that's what that was about. Well, he was tried in a court that doesn't have any authority to try anybody for the laws of the United States. And so that's interesting. Maybe we can do something with that now that, new things come to mind. Now here's another one where this envelope says United States District Court. And that was to Helena. And it's an answer to the complaint that she had put in. I did a video on this before. Yeah, just a second, please. Never fails. And where would that be? So if you went to my site on YouTube, it's Rob Ryder, or Obbryder, and you look at, basically we're talking 3 videos back, or 2 videos back. Official Business of the United States Delivered is where I talk about her case and what we tried to do. And then tell Alex Gilmore versus Jones et al. Is an act of treason. It's about Alex Jones's case. Where I've gotten an answer back where they've told me I need to go to the United States Attorney's Office. Well, now I understand why that is. Because it's the second time I've been told that, so I'll pay attention this time. But so in her case, here we are. All right, when we filed hers, they filed it into the United States District Court. Right, it doesn't say U.S. District Court. It says United States District Court. Received United States District Court. When they answered her answer, because they created an order, and it came from the United States District Court, right, official business. But it says it's in the U.S. District Court, District of Colorado. Again, this isn't the proper court. This is Article 1 court. And we want it to be in the Article 3 court. So we're trying to, basically what we're trying to do is submit a complaint. And they got kicked into this court. And it was an order telling her to direct her deficiencies and blah, blah, blah. Well, that isn't what we wanted to hear. We're really trying to get an arrest warrant issued. They didn't tell her to go see a United States attorney, but they did tell me. In fact, I've been told twice. So back in the day, in 2015, I found a fax number to the grand jury, and I faxed them this complaint, which was received in GR by the U.S. District Court. Right? It doesn't say United States District Court. But I have gotten things from them that says United States District Court. In fact, this came in an envelope that says United States District Court when they replied to me. And this was about Planned Parenthood, that they violated 2 U.S.C. Code 411B, 26 U.S. Code 7201, and 18 U.S.C. 1001. So whatever the proper citation is, and really this is the reason we shouldn't be doing this, we should be giving people our evidence, and they should be doing it because they're the experts, like the United States Attorney's Office. But they did violate these codes. And I got an order from the United States District Court, Western District of Michigan, Southern Division. Right? The court has examined the following documents. Orders the clerk to reject the criminal complaint and return the documents to Robert Allen Rutluski. For the reason noted below, Robert Allen Rutluski is attempting to file a criminal complaint. A criminal complaint may be initiated only by a United States Attorney's Office and not an individual. It is so ordered. Right? Office of the Clerk, United States District Court. But this was received by the U.S. District Court. Hey, guess what? They're not the same. Well, then just here recently with Alex's case, which was the last video I did, I got this answer. United States District Court, Western District of Michigan. Right? It doesn't have a little blah blah in there about Southern Division this time. Order rejecting pleading. The court has examined the following documents received March 21st, 2018, and orders the clerk to reject the preface and return the documents to Robert Allen Retluski for the reasons noted below. Robert Allen Retluski is attempting to file a criminal complaint. A criminal complaint may be initiated only by a United States Attorney's Office and not an individual. Well, now that I've read and understand what they're saying, yeah, they're right. I understand that. Because in the sovereign states, the only powers the court have is under Article 3. And the court can't initiate a court case, right? That has to come because the court is the judicial branch, and it's the executive branch that has the duty to enforce the laws of the United States. It needs to bring the criminal complaint to the court. Private citizen can. I'm supposed to go to the United States Attorney's Office, is what they're saying. So my plan is to take this order with what I sent and send it to the United States Attorney's Office and say the judge says you need to issue a criminal complaint. Says I can't do it, but he understands what it is I'm trying to do. If you have any questions, contact Philip J. Green, U.S. Magistrate Judge. And that's what I'll do next week. And if they won't do anything, well, then that's why it's the idea of my United States District Court in Michigan is in a sovereign state, so it only has Article 3 powers, and it can't start a court case, right? That's done administratively, not judicially, by the executive branch, not the judicial branch. But the United States District Court for the District of Columbia, and we're talking about, this court right here, United States District Court for the District of Columbia, because it's in the District of Columbia, which is its own entity, it's not part of any other state, it's self-governing, and it's governed by the national legislature. They can give it whatever powers they want to, just like a state court can give powers to a state court. In the District of Columbia, they can give powers to the court in the District of Columbia, but not to the courts in the other states because they're self-governing. And their deal was, well, we agree with the Constitution. So, to get something into an Article 3 court in the state requires using the United States Attorney's Office. And as we'll see, it looks like, just making sure that we make it about the Constitution. And so, here next week, a couple of people I've talked to already are planning on going to see the United States District Attorney, and I'm going to send something in, and we'll see what they do. But in the meantime, we may be using this court instead, the United States District Court for the District of Columbia. And, okay, so get rid of Ray. So, part of what I'm going to be reading more of this book, but I wanted to start here because of this phrase or this sentence it has, where the Supreme Court of the District of Columbia is now the United States District Court for the District of Columbia. And the Supreme Court of the District of Columbia had an extraordinary power not possessed by courts or the United States District Courts. It was authorized to issue process against heads of federal executive departments and to enforce their compliance with its judgments and decrees. The thing is, it won't. So this court, whatever the Supreme Court of the District of Columbia is today, which I believe to be the United States District Court for the District of Columbia, has the ability to issue its own process to get the case started. So in other words, they could issue a complaint, but it wouldn't be through the clerk of the court because that's the clerk of the court wearing its Article 3 hat, and we need to go to the clerk of the court wearing the Article 1 hat or whatever it might be, administrative, executive power, wherever it is. So like the court administrator. That's what I'm thinking of. right? The chief judge of the court. They're always the court administrator. And that they can initiate a case. And so this book, or this little PDF, is 23 pages, Catholic University Law Review, from 1980, the District of Columbia Courts, a Judicial Anomaly. And that's easy enough to find online, and I suggest that you do. And in here, on the last page, it gives this timeline that from the time that the district became the, the city of the nation, basically, started out with a thing called the circuit court, which had all the power of the district. And it was that way until 1838, when they split off the local, like state court functions, and put it into a thing called the Superior Court of the District of Columbia. But the circuit court stayed on until 1863, when it finally, it already lost its state. Well, now the federal was taken during the time of President Lincoln, and he split it into two courts, one being the Court of First Instance, Supreme Court of the District of Columbia, general term, and the other court being the Appeals Court, the United States Court of Appeals for the District of Columbia. Prior to that, in the circuit court, one judge would sit as the judge of first instance, and then 3 judges would sit as the appeals court. But it was all part of the circuit court. Okay, so that was then. But what else came at that time? All of a sudden, up pops the U.S. District Court for the District of Columbia. And that's a legislative court. Because this court here, the Supreme Court of the District of Columbia, as we'll find as we read, they say that's the Article 3 court in the District of Columbia. Well, now there'd be 2, because there's the one for the first instance and the one for the appeal. But they're not 2 for courts of first instance, and that's what, these 2 here are for 1863. So as we go through time, in 1934 to 48, they changed the name to the District Court of the United States for the District of Columbia. And then in 1948, they changed it to United States District Court for the District of Columbia, which I believe that's the name we're using today, United States District Court for the District of Columbia. Now, this bothers me some because this is an uppercase and this is in proper case, but, all that'll work its way out. It's just, we'll keep checking things off the box till there's nothing left to check. That's my plan. I'm sticking to it. Okay, and I don't think we need to see this anymore. So, anyways, that's where we're at today. We're at, where it's called the United States District Court for the District of Columbia. Was the federal court of first instance that is now, I believe, to be what's called the general government of the United States. Because this court is in the District of Columbia and it's governed by the legislature can give it all sorts of powers that it can't give the ones that are in the 50 other states. Just can't do it because they're in a sovereign state that's governed under, the Constitution, under Article 3. And if they say, well, we don't want to do that, well, then they couldn't be made to do it. And even if they said yes today, they could change their mind tomorrow. But at least here in the district, well, this is the way it is. It looks like it's going to be the court that has general government powers. Now, where is all that coming from? Where would that be coming from? Besides the history. So I'm going to, like I said, mainly be reading a court case. You can find online. It's the United States Supreme Court, O'Donoghue versus United States, 1933, which is like 1 year before this court that we're talking about is going to change its name, or courts that we're talking about, because they changed their name in 1934. From whatever they were, they're going to change to a different name. And one judge from the Supreme Court of the District of Columbia and one judge from the Court of Appeals of the District of Columbia brought a claim that's going to be heard by the Supreme Court. And it had to do with the fact that, because I don't want to read this whole thing, it's 21 pages, but what it has to do with is that these judges were told their wages were going to be diminished. And they said, well, no, our wages are fixed by the, um, by the Constitution. We're an Article 3 court. And the whole idea was, well, let's get it figured out. Right? Because each plaintiff aveers a reluctance to institute a suit, which may result in personal benefit to himself, but feels it's his duty to the court, to the bar, to the citizens of the District of Columbia, and to the people of the United States to have the status of these important courts defined and settled as soon as possible. In other words, let's, define who we are. But prior to that, so it is further averred, this is what the plaintiffs were saying, that the Supreme Court and Court of Appeals of the District of Columbia, the district, are vested by acts of Congress with all the jurisdiction and all the power conferred on the United States by the Constitution under Article 3. In other words, right, they're courts of the United States. That such jurisdiction and power have been exercised by the Court of Appeals since 1893 and by the Supreme Court of the District and its predecessors from the establishment of the government in 1801, I guess, is when you could say is when they established the District of Columbia. And that only to the extent that Congress has enlarged and extended the powers of said courts did the body act under any other than Article 3, and that they are none the less such inferior courts because by reason of their location at the seat of government. Congress under Article 1, Section 8, Clause 17, yada, yada, yada. If we look at that real quick, what does that say? 9, and so it's this one right here. So this is Article 1, Clause 8, Section 17. To exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 miles square, as may be, by cessation of the particular states and the acceptance of Congress, become the seat of government of the United States. That'd be the District of Columbia. And to exercise like authority over all places purchased by the consent of the legislature of the state in which it shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. Well, I'm going to say, well, then they're talking about any place you see a gold fringed flag hanging. That those have been ceded to the United States. They wouldn't have it, the United States wouldn't have its flag there. And, so like a guy in Arizona had found out in Prescott, Arizona, that the post office isn't on the taxing maps. And in the post office is a courtroom. Right? So it's a federal court. Or could be a federal court. I don't know if they're using it, but that kind of stuff. So nothing is ever quite as it seems. Okay, but the government said that they are not judges of inferior courts within the meaning of Section 1, Article 3 of the Constitution. Right? And so when they say inferior courts, under the meaning of Article 1, Section 1 of Article 3 of the Constitution, they're talking about district courts. Does Section 1, Article 3 of the Constitution of the United States apply to the Supreme Court and to the Court of Appeals of the District of Columbia and forbid a reduction of the compensation of the justices thereof? They called the judges. Until 1948, all these judges were called justices. Can the compensation of the Justice of the Supreme Court be lawfully diminished during his continuance? That's what they were going to try to figure out. So first they had to figure out what they were. And really that's what this parts I'm going to read to you are about. In framing the Constitution, therefore, power to diminish compensation of a federal judges was explicitly denied. Okay, so if they can diminish the compensation of a judge, he's not a federal judge. This could be important someday. Hamilton said the complete independence of the court of justice is particularly essential in a limited constitution. In the general course of human nature, a power over man's subsistence amounts to a power over his will. Ain't that the truth? The judicial department comes home in its effects to every man's fireside. It passes on his property, his reputation, his life, his all. All right? Well, the judicial power of the United States is vested in Article 3 courts. So who else is taking our property? Because it isn't an Article 3 court. Propriety and necessary dependence judge, evident reason for nature of their office, since they are to decide between government and people as well as contending citizens. The judges of the Supreme Court and Court of Appeals of the District of Columbia are of equal rank and power with those of other inferior courts of the federal system. Okay, well, if they're equal with the other courts of the federal system, then who's the federal judges? Is it the U.S. District Court or the United States District Court? I think they're going to tell us it's the United States District Court. The courts of the district, then to the inferior courts of the United States. What does that mean? Indeed, the reason which have been set forth, and which impelled the adoption of the constitutional limitation, apply with even greater force to the courts of the district than to the inferior courts of the United States located elsewhere. That would be the other United States district courts. Because the judges of the former courts are in closer contact with and more immediately open to influences of the legislative department, and exercise a more extensive jurisdiction in cases affecting the operation of the general government and its various departments. Right? They got other powers than the courts elsewhere in the Union. This court has repeatedly held that the territorial courts are legislative courts, created in virtue of the national sovereignty under Article 4, Clause 3, Section 2, Clause 3, of the Constitution. The territory, and this is interesting, where it says, vesting the Congress in the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and that they are not vested with any part of the judicial power defined in the 3rd article of the Constitution. So they can't try anything that has to do with the United States. They don't have the authority in a territorial court. Only an Article 3 court can try you for an offense against the United States. Do the courts of the District of Columbia apply in like situation in virtue of the plenary power of Congress under Article 1, Section 8, Clause 17, to exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 miles square, is made by cessation of parties, states, and acceptance of Congress becomes seat of government of the United States. This inquiry requires consideration first of the reasons upon which rests the decision in respect of the territorial courts. The pertinent question there was whether the judicial power of the United States described in Article 3 of the Constitution vested in the superior courts of the Territory of Florida, and it was answered negative. Of course, they have some court case they're talking about. But they said that the superior courts of the Territory of Florida were not Article 3 courts. The judges of the Superior Court of Florida, the court said, hold their office for 4 years. These courts, then, are not constitutional courts in which the judicial power conferred by the Constitution on the general government can be deposited. Okay, so under the Constitution, the judicial power is going to be conferred on the general government. And they gave it to the United States District Court for the District of Columbia. They are incapable of receiving it. They are legislative courts, right? That's why they can't do anything under the Constitution. So like the Superior Court of Florida, it could try whatever laws have been passed for the territory of Florida, but not the United States. Except when you go to court, you don't think you're being tried for some territorial law. They're taking you there because, it's an IRS violation. Or food and drug has brought you in, or whatever the criminal case is. But when you get there, they're not going to try you in an Article 3 court. They're going to try you in an Article 1 court using some kind of cobbled together numbering system to make it look like it's a violation of United States Code, but they're never going to say it's a United States Code. Not on the true paper of the court. Whatever they say on the out there in the courtroom, that's a bunch of blah blah blah. That's like a show. That's an act. What matters is what's the official records in the back room. As we saw in Samuel G's case, they're not trying him for any United States Code violation. The jurisdiction with which they are vested is not part of the judicial power which is defined in the 3rd article of the Constitution. Can't get any clearer than that. A sufficient foundation for these decisions with respect to territorial courts is found in the transitionary character of a territorial government. In other words, they're not supposed to be around very long, so there's no reason to give somebody lifetime appointment, during good behavior. And the other things that Article 3 judges get. The absence from the Constitution of such guarantees for territorial judges was no doubt due to the fact that the organization of governments for the territories was but temporary and would be superseded when territories became states of the Union. In this connection, a peculiar language of the Territorial Clause, peculiar language of the Territorial Clause, Article 4, Section 3, Clause 2 of the Constitution should be noted. In other words, there could be a test. By that clause, Congress is given the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. Literally, the word territory, as they're used, signifies property, since the language is not territory or property, but territory or other property. So in Article 4, Clause 3, Section 3, Clause 2, the territory or other property, right? That's not a territorial government. That's just the woods. It's an unorganized territory. They don't have a legislature yet. So it's like the United States just being a portion of the surface of the earth. There thus arises an evident difference between the words the territory and a territory of the United States. The former merely designates a particular part or parts of the earth's surface, the imperially extensive real estate holdings of the nation. The latter, a territory, is a governmental subdivision. Not political, governmental subdivision, which happened to be called a territory, but which quite as well could have been called a colony or a province. The territories, it was said in the first, some case, are but political subdivisions. Well, that's what Michigan is. It's a political subdivision. The territory, not a territory, of the outlying dominion of the United States. So it's like, whatever they were supposed to do to become a state was never really done, and they're still a political subdivision. They're not a governmental subdivision. The territory just means defined territorial land, right? So the territory of Michigan, you look at a map and you see this thing says Michigan, well, they're talking about the surface of the earth. Nothing to do with the form of government. Since the Constitution provides for the admission by Congress of new states, Article 4, Section 3, Clause 1, it may be properly said that the outlying continental public domain, of which the United States was the proprietor, was from the beginning destined for admission as a state or states into the Union. and that as a preliminary step forward, that foreordained end to tide over a period of ineligibility. Congress from time to time created territorial governments, the existence of which was necessary, limited to the period of pupillage. So, we're going to have this outlying area. We got to put something in there to oversee it, and it would be the military, some type of military government. In that view, it is not unreasonable to conclude the makers of the Constitution could never have intended to give permanent tenure to office of irreducible compensation to a judge who was to serve during a limited or sometimes a very brief period under a purely provisional government. The impermanent character of these governments has often been noted. Thus, it has been said the territorial state is one of pupillage at best. Right? So the territory of Florida, it's one of pupillage. It's not a state of Florida yet. The territory under the constitutional laws of the United States is an inchoate state. In other words, not completely formed yet, I guess. During the term of their pupillage as territories, they are mere dependencies of the United States, which means they can't try United States law. They're dependent on the United States. How different are the status and characters of the District of Columbia? With an exclamation point. The pertinent clause of the Constitution, Article 1, Section 8, Clause 17, confers the power of Congress to exercise exclusive legislation over such district as may become the seat of government of the United States. The district as the seat of the national government is as lasting as the states from which it was carved or the union whose permanent capital it became. Right? So the District of Columbia is the capital of the one nation under God, indivisible, with liberty and justice for all. The same district is hereby accepted for the permanent seat of government of the United States. In the district clause, unlike the territorial clause, there is no mere linking of the legislation process to the disposal and regulation of public demand. The landed estates of the sovereign, within which transitionary government tied for periods of pupillage may be constituted, but an unqualified grant of permanent legislative power over selected area, set apart from the enduring purpose, or for the enduring purpose of the general government, to which the administration of purely local affairs is obviously subordinate and incidental. The district is not an inferior subdivision of an outlying dominion of the United States, but the capital, the very heart of the Union itself, to be maintained as the permanent abiding place of all its supreme departments, and within which the immense powers of the government, of the general government, were destined to be exercised for the great and expanding population of the 48 states, and for a future immeasurable beyond the prophetic vision of those who designed and created it. And for a future immeasurable beyond the prophetic vision of those who designed and created it. So it's got a lot of power, apparently. Over this district, Congress possesses the combined powers of a general and of a state government in all cases where legislation is possible. The power conferred by Article 1, Section 8, Clause 17 is plenary. I think that's like all-inclusive. It's all. It is meet that so powerful sovereignty should have a local inhabitation, the character of which might absolutely control, and the government of which it should not share with the states in whose territory it exercised but a limited sovereignty. Supreme, it is true, in cases where it could be exercised at all, but much restricted in the field of its operation. So everywhere else but D.C., it's a very limited sovereignty. Within D.C., well, it's a national government. They can do as they please. The object of the grant of exclusive legislation over the district was therefore national in its highest sense, the city organized under the grant became the city, not of a state, not of a district, but of a nation. Right? So it's like Vatican City. It's some city that has the power of the nation that if you're a member of, they have in persona jurisdiction over you because you're a citizen of the United States. But now if you look at most of this paperwork that they want us to sign, it always says that you're a citizen of the U.S. of the U.S. You're a U.S. citizen. So like on a W-9 form, they want the signature of the U.S. citizen. Right? Well, that would be somebody out in the territory, not in the United States. That kind of stuff. Right? But if it was done right, well, then the District of Columbia would be the, seat of government, the city of the nation. What nation? Well, the one nation under God, United States. In the same article, which granted the powers of exclusive legislation over the seat of government, are conferred all the other great powers which make the nation. All this has happened in the District of Columbia. There is nothing in the history of the Constitution or the original amendments to justify the assertion that the people of the district may be lawfully deprived of their benefit or of any constitutional guarantees for life, liberty, property, especially of the privilege of trials by jury in criminal cases. It is important to bear constantly in mind that the district is made up of portions of two of the original states and was not taken out of the Union by secession. This district has been part of the states of Maryland and Virginia. It has been subject to the Constitution and was part of the United States. The Constitution was attached to it irrevocably. So in other words, just because they pulled the District of Columbia out of these states, it didn't take it out of the Constitution. The mere cessation of the District of Columbia to the federal government, relinquishing the authority of the states, did not take it out of the United States or from under the aegis of the Constitution. In other words, the Congress could not do indirectly by carving out the district that it could not do directly. They can't change the fact that the Constitution applies to the District of Columbia. The district still remained part of the United States, protected by the Constitution. Indeed, it would have been fanciful construction to hold that the territory, which had once been part of the United States, ceased to be such, being ceded directly to the federal government. That the Constitution is in effect in the territories as well as the district has been so often determined in the affirmative, it is no longer an open question. So in other words, it's in effect in the territories, and if they say that you've offended the United States law, 18 U.S.C. something, or the Constitution, whatever it is, under Article 3, then it has to be in an Article 3 court. But they're taking people to Article 1 courts. The question which arises is not whether the Constitution is operative, for that is self-evident, but whether the provisions relied on is applicable. And I think this is the part we need to focus on, is applying the proper part of the Constitution on the proper people for the proper reason, such as to have a criminal complaint issued here in the United States, other than the District of Columbia. I can't go to the United States District Court directly. I need to go to the executive branch, which is the United States Attorney's Office, and have them do it. I've had 2 different magistrate judges tell me that now, so I'm going to go try it and see what happens. The observation already quoted at the decisions in respect of the inapplicability of the 3rd article of the Constitution to the territorial courts grow out of the presumably inferior nature of the territorial government. As the only judicial power vested in Congress is to create courts whose judges shall hold their offices during good behavior, it necessarily follows that, if Congress authorizes the creation of courts and the appointment of judges for a limited time, it must act independently of the Constitution and upon territory which is not part of the United States within the meaning of the Constitution. Because if it was in the United States, well, then all those things would be under Article 3. But because it's not in the United States, it can't be under Article 3, and they have to have a territorial government. And they're going to have to, create some courts for it. But they won't be Article 3 courts. So they can adjudicate the special laws of the territory, but they can't do it in the United States. It is sufficient to say that this case, blah, 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 that the judicial clause of the Constitution has no applications to courts created in the territories. That the District of Columbia and the territories are, so after an exhaustive review of the prior decisions of this court relating to this matter, the following propositions, among others, were stated as being established. Right, these 4 points. That the District of Columbia and the territories, the District of Columbia, the territories, are not states within the judicial clause of the Constitution giving jurisdiction in cases between citizens of different states. So just because somebody's in the District of Columbia and one of the other territories, Michigan, right, they're not states under the Constitution to give diversity jurisdiction. The territories are not states within the meaning of Rev. St. 709, permitting writs of error from this court in cases where the validity of a state statute is drawn into question. That the District of Columbia and the territories of the states, as the word is used in treaties with foreign powers with respect to ownership, disposition, inheritance of property. Oh, they are states, as the word is used in that. They're not states in the idea of being territories, but they are under treaties. That the territories are not within the clause of the Constitution providing for creation of the Supreme Court, such superior courts as Congress may see fit to establish. Right? So the territories are not under Article 3. The significant point to be observed in this enumeration is that the opinion is so careful to distinguish between those propositions which relate both to the territories and the District of Columbia and those which relate to the territories alone, so that when the court in paragraph 4, all right, that'd be an Article 3 court, accepts from the operation of Article 3 of the Constitution only the territories, accepts from the operation of Article 3 of the Constitution only the territories. In other words, it didn't say the territories in the District of Columbia, it just said the territories. So the District of Columbia, then, courts are under Article 3. It is to be remembered that the case referred to territorial courts only, all right, so we got to keep that in mind. Chief Justice gave as a conclusive reason why the territorial courts are not constitutional courts vested with judicial power designated in Article 3. They are incapable of receiving it. It's not hard to justify this observation with respect to courts created for a purely provisional government. But the District, Supreme Court, and Court of Appeals are permanent, established federal courts of the United States as part of the federal judicial system. In light of all that has now been said, we are unable to perceive upon what basis of reason it can be said that the courts of the district are incapable of receiving judicial power under Article 3. Now, remember, that's what this whole case is about. Are these courts Article 3 courts or not? Right? The United States District Court for the District of Columbia and the United States Court of Appeals for the District of Columbia Circuit, I think is what its name is today. The fact that Congress under another and plenary grant of power has conferred upon these courts jurisdiction over non-federal causes of action and over quasi-judicial or administrative matters does not affect the question. And this is the part that we need, is that they can't do this outside of the District of Columbia, but they can give quasi-judicial and administrative matters to the court within the District of Columbia. In other words, this court said it possesses a dual authority over the district and may clothe the courts of the district not only with jurisdiction and powers of federal courts in the several states, but with such authority as a state may confer on her courts. Instances in which congressional enactments have been sustained which conferred powers and placed duties on the courts of the district of an exceptional and advisory character are found in, and here's some other court cases. And so this is those exceptional powers that was talked about in the PDF that, to initiate process for proceedings against the heads of federal agencies. Well, that may be handy. It's just who's the person you got to give the complaint to. Subject to the guarantees of personal liberty and the amendments in the original Constitution, Congress has as much power to vest courts of the district with a variety of jurisdictions and powers as state legislatures has in conferring jurisdictions on its courts. A state constitution sees fit to unite legislative and judicial powers in a single hand. If in creating and defining the jurisdiction of the courts of the district, Congress were limited to Article 3, as it is in dealing with other Article 3 courts, the administrative and other jurisdictions spoken of could not be conferred upon the former. But the clause giving plenary power of legislation over the district enables Congress to confer such jurisdiction. It's really just that simple. It's in the Constitution. They can give it extra powers. Does the judicial power conferred extend to the cases enumerated in this article? If it does, the judicial power thus conferred is not and cannot be affected by the additional congressional legislation enacted under Article 1, Section 8, Clause 17, imposing upon such courts other duties which, because that special power is limited to the district, Congress cannot impose upon inferior courts elsewhere. Inferior federal courts. The two powers are not incompatible, and we perceive no reason for holding that the plenary power given by the district clause of the Constitution may be used to destroy the operative effect of the judicial cause of the district or within the district. To confer upon courts district administrative functions which outside the district it may not confer upon courts created solely under Article 3. It's dual constitutional right, in the first place, to establish courts of law and invest them, as it has, with power of jurisdiction over all cases and controversies which, under the authority of Article 3, it has invested in the district courts of the United States. And in the second place, in the exercise of the power of sovereign state under the provisions of Section 8, Article 1, has further imposed upon them jurisdiction and power which it cannot impose upon other like courts functioning outside the district. There is no inhibition in the Constitution against the exercise by Congress of this dual power. When Congress created the two courts, the district courts of the United States and Supreme Court of the District of Columbia, and gave each within its own sphere identical jurisdiction, that it drew its powers from the same source, even though it was necessary, it should have recourse to another provision of the Constitution in order to clothe the courts at the seat of government with other and additional authority not permissible under Article 3. This was interesting. When the Congress created the two courts, the district courts of the United States and the Supreme Court of the District of Columbia, and gave each within its own sphere identical powers, so whatever powers it gave to the state court of D.C., it gave to the National Court of the United States. And so that'd be good to go look to see, well, what do you do in a Supreme Court of the District of Columbia? It gave to each within its own sphere identical jurisdiction. Or, I got to think about what that's saying. What is the Supreme Court of the District of Columbia? Is that the one we're talking about? Aye, aye, aye. This is the problem with this stuff. It gets to be so confusing. The Supreme Court of the District of Columbia. The Supreme Court of the District of Columbia. Supreme Court of the District of Columbia. But the isn't capitalized. And I believe it was, that is part of the proper name of the court. The Supreme Court of the District of Columbia. Okay, well, we'll figure it out. To clothe the courts at the seat of government with other and additional authority not permissible under Article 3. I guess my point is, are they talking about the court of first instance or the appeals court? Because the appeals court would be the Supreme Court of the District of Columbia. If the United States District Court for the District of Columbia is a court of first instance, and the United States Court of Appeals for the District of Columbia Circuit is the appeals court, it's actually the higher court. It's the Superior Court of the District of Columbia, which answers to the United States District Court, not the United States District Court, the Supreme Court of the United States. Okay, and on 1801, Congress established a circuit court. The judges thereof to hold office during good behavior, giving the court judges the same powers as vested in the circuit courts of the United States and judges thereof. In 1863, the court was superseded by, and its jurisdiction conferred upon, the present District Supreme Court, which is now the United States District Court for the District of Columbia. Many acts of Congress refer to these courts as courts of the United States. In the District Code, the Supreme Court of the District shall be deemed a court of the United States. And if it's a court of the United States, then it's an inferior court. I wonder if I put that comma there, or if that was there. Or did I make a mistake? Because why would they put a comma between United, States? Deemed a court of the United, States. And Section 48, the provisions shall have and exercise the same powers and jurisdiction over the district courts of the United States. Sole virtue power, general powers of the district court of the United States. It is true, of course, Congress, in conferring life tenure upon the judges of the courts of the district and in doing the other things mentioned above, might have done merely as a matter of legislative discretion without deeming it to be a matter of constitutional compulsion. In other words, pretty much everything that a court could have under Article 3, the legislature could give them the same powers, but not through the Constitution. I guess. Nevertheless, a practice so uniform and continuous indicates that some degree of persuasiveness force that Congress entertained the view that the courts of the district and inferior courts of the United States sitting elsewhere stood upon the same constitutional footing. It's a maxim not to be disregarded, said Chief Justice Marshall, that general expression, every opinion, are to be taken in connection with cases in which the expression is used. Blah, 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 blah. Much more of this do we need? Because we're just about done. Congress may vest non-judicial functions in courts of the district. Well, that's the important thing. Administrative or legislative functions may be vested in the courts of the district, but adds that this may not be done with any federal courts established under Article 3 of the Constitution. Taken literally, it seems a negative view of some other thing, but should be confined to federal courts in the states as to which no such dual power exists. Right? So what they're saying here would be true. They can't give they can't give an Article 3 court in a sovereign state any administrative or legislative functions. But they're saying they can do it in the district. We hold that the Supreme Court and Court of Appeals of the United States or of the District of Columbia are constitutional courts of the United States ordained and established under Article 3 of the Constitution. So, you want to know where an Article 3 court is? They're saying that the United States District Court for the District of Columbia is. Unless there's one more fold in the logic, and we need to find the one where this would be proper case. But until then, it looks like it's sitting in the right place. We can't go to the court in its Article 3 hat because the Article 3 court can only adjudicate matters. We need to go to the side where it has administrative functions, where it can initiate a proceeding against an administrative head of a federal office, department. So that's enough on that. And let's see, how long has this been going? It's already over an hour. These things just take so long. Sorry, folks. It's just kind of the way it is. Anyways, just really quick in this book, the District of Columbia Courts, a judicial anomaly. Confusion results when Congress named the district trial courts the Supreme Court. Congress established the Supreme Court of the District of Columbia in 1863. Act of March 3rd, 1863. Chapter 91, 12 Stat 762, which is nice about the footnotes of where all the stuff came from. The United States District Court for the District of Columbia. Okay. Today, 4 courts predominate: the United States Court of Appeals for the District of Columbia Circuit, the United States District Court for the District of Columbia, the District of Columbia Court of Appeals, the Superior Court of the District of Columbia. Each of them is to some degree an offshoot of the district's first court, the Circuit Court of the District of Columbia, established by Congress in 1801. Right, so they all started here with this court. And by the time this was written in 1980, we're down here to, dealing with these courts. United States District Court, District of Columbia, United States District Court for the Appeals of the District of Columbia Circuit, the Superior Court of the District of Columbia. Now, the interesting thing, this court has general sessions, and that was something that was brought up before, that when the court was in general term, I don't know if a general session is the same or not, but that's when the court was wearing the proper hat. I think it actually says it here in this book that we're reading. The Supreme Court held the Court of Appeals, District of Columbia, is Article 3 court. Supreme Court ruled District of Columbia Court of Appeals and Superior Court are Article 1 courts. Right? The Supreme Court held that persons convicted of violations of the D.C. Code might not have no right to have their cases heard by Article 3 judges. So if they were trying you by the code of the place you were at, well, then you couldn't have access to an Article 3 judge. But they're not charging you by the code. They're pretending to charge you by the law of the United States. Because you are in a sovereign state. There is no territory. There shouldn't be any territory courts here. If the state of Michigan is a sovereign state, there's a star on the flag for it, then there's no need to have territorial courts. There should just be courts of the United States. District Court of the United States for the District of Columbia is what it was. Right? That's what it was named in 1936. In 1948, it was changed to the United States District Court for the District of Columbia. Right, but see, it's all proper case. And the other one we looked at, when we look online, it's got the damn thing in uppercase. And 1948 to date, the years during which the district attained something in the nature of a state court system of its own. By act of Congress, District of Columbia became seat of the national government in 1800. 1 year later, Congress authorized court's chief judge to hold a district court of the United States with the same powers and jurisdiction enjoyed by other United States district courts. Thus, the circuit court was both a federal and local court. Chief judge of the circuit court, this guy named Cranch, was originally appointed associate judge in 1801 on the eve of Adams' departure from office. Cranch was included among the midnight judges so bitterly condemned by Jefferson and the Republicans. Maybe what Marbury versus Madison was about. But in 1806, Jefferson appointed him anyways. He's best remembered. So here's the guy, this Cranch, that was in charge of the court that we're really trying to get, whatever piece of the remedy is left. I believe it's, this guy had a piece of it, Cranch. And I don't know which of the courts it's in now, but, he was the one who had the power back in the day. And his other duty was Cranch is best remembered outside of Washington, D.C. as the reporter for the Supreme Court of the United States. So that's the other guy I'm going to go look for. Who's the reporter of the Supreme Court of the United States, and send something to him. Because, he was the judge of this Supreme Court, or this circuit court, the chief judge of the circuit court, but he was also the reporter for the Supreme Court of the United States. Chief Justice Cranch occupied a position at district court analogous to that of Chief Justice John Marshall in the Supreme Court, and to him is generally given credit for the stability of the early court. The final events occurring during circuit court's existence caution against over-reliance by the judiciary on protection from the legislature. In 1863, there was severe conflict among the three branches of government, within the judiciary getting the worst of it. The condition that triggered the conflict was Merrick's issuance of a writ of habeas corpus, and President Lincoln suspended the writ and had the judge put under arrest. The episode led to the district's first case of court packing, a subject usually identified with Franklin D. Roosevelt rather than Lincoln, although Roosevelt was unsuccessful in his attempt to pack the membership of the Supreme Court. Lincoln encountered little difficulty in persuading Congress to abolish the circuit court and create a substitute, all of whose members were to be appointed by the president. And the substitute that he created was U.S. District Court for the District of Columbia. I'm thinking, which, Lincoln could appoint them. He put military officers in. Lincoln maneuver occurred in 1863 when the Union's fortunes were low and safety of the capital was in danger. He was determined to have a court in the District of Columbia whose members were unquestionably loyal. Well, they would have been members of the military. Not members of the judiciary and not members of the legislature, but members of the military. They're unquestionably loyal to the president, not the other two branches of government. And so I think that started the U.S. court, that legislative court. In this manner, 3 judges who had been appointed to serve during good behavior were forced out of office without any proof of misbehaving by the executive legislative steamroller. And then 1863, it started another court. Both courts were first instance when they sat in general term, right? So the Supreme Court of the District of Columbia. Where are you? The Supreme Court of the District of Columbia. 1863, 1934. Was modeled on the Supreme Court of the State of New York. Both were courts of first instance, but when they sat in general term and bank, they served as appellate court, hearing appeals from rulings of the individual judges. Well, that's how Michigan's territorial court started up. And the district and appeal from the ruling of the general term could be taken directly to the Supreme Court of the United States. So hear it before one, then hear it before three, and then go to the Supreme Court of the United States. Judges of the district Supreme Court were authorized by Congress to hold district court of the United States. Oh, all right. Second, the Supreme Court. We already read that. Essentially, a local court, the Supreme Court of the District of Columbia, adjudicated controversies of a type generally associated with state courts. So those would be things that happen within the District of Columbia. And the other one must be for things that happen out of the District of Columbia. Right? Not things of a state nature, things of a federal nature. Congress was a national legislature. Right? The Supreme Court of the District of Columbia had an extraordinary power not possessed by state courts or United States district courts. So where did this extraordinary power go? That's really what we're looking for is, well, where's the power? Who's authorized to issue process against heads of federal executive departments and to enforce their compliance with its judgment and decrees? Because whoever that is has got both judicial and administrative powers. The full implications of such powers were unrealized until well into the present century. And it said here, it was not until the New Deal legislation that the executive branch found itself continually in court. You have to go look at that court case. Okay, 1893, Congress established a new federal court, the Court of Appeals, and abolished the appellate jurisdiction of the District Supreme Court. Okay. The name of the new appellate court was changed in 1934 to the United States Court of Appeals for the District of Columbia, and in 1948, the United States Court of Appeals for the District of Columbia. That's really the Supreme Court of the District of Columbia, right? It's the appeals court to the lower court, which is why maybe this is the court they're speaking of. But hey, it's a court in D.C. It's like one of 4 courts. Instead of being one of 100,000, we're down to a 10-mile square and trying to figure out which one of these courts here, because all the power started here in 1801, and we're today after 1948, right? We got 1, 2, Superior Court, District of Columbia, 3 courts. There may be one more since then. They may have made an appeals court even now out of this. Because in a way, you could say it's a state matter, because if you're going to bring it against the heads of the executive branch, well, they're all in the District of Columbia. So in a way, that is a state matter. Twists and turns. Until 1973, the United States District Court exercised exclusive jurisdiction over all felony cases arising in the District of Columbia and the concurrent jurisdiction with the Superior Court. After a 3-year takeover, the Superior Court assumed jurisdiction over all criminal matters except cases falling within the exclusive jurisdiction of the federal courts. Court Reform Act and Criminal Procedure Act of 1970. Got to read a little bit about that. General term, which is ultimately became the United States District Court for the District of Columbia. So the Supreme Court of the District of Columbia moved into City Hall in 1863, and at the time the Circuit Court was abolished. The general term, which ultimately became the United States District Court for the District of Columbia, held its sessions for a time across the street at Building D, now occupied by the Court of Military Appeals, before finally moving in 1952 to the United States Courthouse on John Marshall Place. All right, so where is the United States Courthouse? On John Marshall Place. The special term of the Supreme Court of the District of Columbia remained in the City Hall and moved in 1952 to the new federal courthouse on John Marshall Place. So they're all moving back to the same place. Okay. As national revenues move toward being counted in terms of trillions, well, we're there now, also increasing are the dangers of massive corruption. Do you think? The courts of the nation's capital must carry the burden of providing a forum for prosecutions when that becomes needed. Prosecutions what? Well, that would be corruption. Because the Social Security Administration has taken it on its own to decide that for it, your legal name is just your first name and your last name, forgetting the fact that in the Code of Federal Regulations, which is the act for the Real ID Act, as they call it, for identification, it says your full legal name is your first name, middle name, last name, no initials. So if you filled the form out for the secretary or for SS5 form to get a Social Security card, and you put your name in the middle name box, like Robert Allen, and put Allen in the middle name box, well, Social Security is going to say, well, that's not part of your legal name. We're just not going to include it. And all of a sudden, your record's been corrupted because it's not in your full legal name. It's in a name with just your first and your last. Well, who told them they could do that? Right? So that's what I'm talking about. We need to have them arrested, or have them change it, or be arrested, or have them change it and arrest them anyways. Prior to the District of Columbia Self-Government and Governmental Organization Act, all judges of the district courts were nominated by the President, appointed by Senate approval. Okay, so anyways, that's really all I had on that. It's too much to try to do in a short period of time, but I can understand now, at least for myself, why, well, you can't just go directly to the court. You would have to go to the United States Attorney's Office, and we need to make it what they call a federal matter. In fact, let me show you that. They actually call it that in the Attorney's Manual. Partial list of federal matters investigated by the FBI. Right? Federal matters. They're not using any codes. They're using words. Much more like common law. Such as, I had my favorite here, impersonation. Right there. Right? Partial list of federal matters investigated by the FBI. This is out of the U.S. Attorney's Manual. United States Attorneys. Office of the United States Attorneys. I know this says U.S. but, hey, you got to work with what you have. It's still called the United States Office of the United States Attorneys, and that's who I was told I needed to go to. All right, that's what they just told me with Jones. Robert Allen Vertlewski is attempting to file a criminal complaint. They're not denying it's a criminal complaint. A criminal complaint may be initiated only by the United States Attorney's Office and not by an individual. So I'm going to go to the United States Attorney and say, hey, the judge says you need to issue an arrest warrant or you need to issue a criminal complaint. And then, whatever else happens after that. But my part will be done. We're supposed to be given a thing like a statement of evidence. And there was one place, where did I see that? That was in here too. Oh. Had to do with qui tam prosecutions. I'm not really sure where it was. But it talks about that the U.S. attorney forwards to the FBI a copy of the complaint and a thing called a statement of evidence. Well, if we can't do the complaint, then it must be the United States Attorney's Office that does. And they're going to take that and a thing called the statement of evidence, which I think is basically what we're giving them. Not really a deposition, but we're going to swear to our statement. Or we're going to give them probable cause, and they're going to go do it. So, okay, well, I needed to get this video out of the way so I can do a video on exactly what it is we're going to try next. But that'll be in the next video. So for now, this was just kind of to go through this act and this, well, that court case, not really an act, Supreme Court case, and then this book about the jurisdiction of the District of Columbia courts, a judicial anomaly, and why they are the way they are. Okay, you all have a great day. See you.